don't think we need any more information. It's right there.
Okay.
Do we need to give Ms. Escrow the opportunity to speak before we close, or
That's up to us.
it is her hearing? That's why I'm curious. But
And I'm not sure if her attorney was speaking on her behalf or Miss Escrow wanted to also.
We'd just like to have closing statements, so I don't think that's very long. I know we'd all like to go home, so I don't think we're interested in having anything very long, but I would like to summarize this testimony that we have here.
Okay, so we'll take closing statements.
Great. So I assume it's their burden, so I'll go first if you don't mind. My understanding of the testimony here, and I am a constitutional law attorney. So you may or may not take it from me, but what I heard here was an admission of both violation of Miss Escrow's First Amendment and Fifth Amendment rights. There's absolutely no question that she has a right to make statements, be they disparaging or otherwise, against the city of Amory. And that if the city of Amory terminates her because of those statements that she makes off the clock, so even if she was the county watcher, even if she takes a picture, but this is all that we have, is that she merely took a picture of a public document. That's protected free speech. If Miss Escrow is terminated, her free speech rights will be violated. We also heard this gentleman testify that there's a work rule, that he gave her this document that ordered her to testify. And we also saw that this interrogation was custodial in nature, not just because it happened in a closed door room of an interrogation. There's a reason why police tell suspects that they're free to leave. We didn't hear that. There's a reason why police leave doors open. There's also a reason why police officers take classes, possibly those who don't know that. One of those reasons that police officers who are well-trained leave the doors open to interrogation rooms is because if it's not a custodial interrogation, the suspect needs to be free to leave. Now, that matters, but what matters even more, again, is that there is a work rule that is in place that is ordering her to tell the truth under fear of termination. Once Mr. Hainsel put that document down, that invoked Miss Escrow's Fifth Amendment rights against self-incrimination. Mr. Hainsel had one of two choices. He could have used that body cam that was coerced, that coerced testimony, to further his investigation, or he could have used it for disciplinary purposes, but he couldn't have done it for both. That's the law. That's called Garrity is the federal case, Odson is the state case. I'm just in the appeals court on that issue right now, just for example, so maybe it's on my mind. I'm sure it'll be on my mind a lot further if this termination is confirmed. I'm sure there's going to be a lot more chance for a lot more testimony from all sorts of people on this issue, because again, Miss Escrow, and it looks like there's a conspiracy here between the clerk, Mr. Jansen, and the police chief here to violate my client's constitutional rights. And we also have evidence that this gentleman is losing a substantial amount of money. We have evidence that my client participated in making an excess complaint parts of which caused this gentleman to lose a lot of money. Now, we've heard, and everybody in this room has heard him say, that doesn't bother him. Now, we all know that's false. Everybody here, everybody at that podium, everybody watching this on YouTube, who will be watching this on YouTube, everybody in the stand there today knows that that's a false statement. It's just one of many. And that's really where the crux of where we are at right now is, and this is, you go further and further and further down this road every time. We send you a letter, and here we are 3 weeks later, and there's retaliation. You all got a copy of it. Mr. Hainsel got a copy of my letter. It specifically went through First Amendment issues and First Amendment retaliation. Now look out in the stands there. You're going to see much of the police department sitting with Miss Escrow. That's not a mistake. I'm going to guess that the officers who are here, even though they're under fear of retaliation, are here because they want the kind of police department that follows the law. Because if you can't follow the law when even terminating an employee, how can you follow the law when prosecuting crime? I submit this gentleman here is already cooked. And that's because Brady is going to arise every time he's called to testify in the future. He couldn't keep his story straight from 1 minute to the next. First, something was false for one reason, then it was false for another reason, and then lo and behold, the whole argument, the whole logic underpinning this entire letter, he admits he did not know, he does not know today. And I'm sorry these facts are inconvenient. And I understand that the same people who are judging this issue are the same people who put this police chief in place. And they're same people who are answerable to the citizens of the city of Amory for both this decision here and the decision to hire this police chief, who again had no management experience of any kind. He was a police officer from the city of Milwaukee. Okay. You guys made your choice. That's a political choice. You're sticking with it. The problem is that you're allowing multiple violations of the law to occur, and you're not doing anything about it. You didn't do anything the first time. And so what happens? He goes and writes a false statement, and it's false because he can't sign his name to this document. He didn't do it. He could have, didn't do it. And why do people sign documents? To tell the world that I agree with everything in this letter and it's true. That's why we sign documents. But under cross-examination, which is the right Miss Escrow had, he couldn't back up the statements that he didn't even bother to sign his name to. He couldn't. False. There's nothing false about Miss Escrow, even under his best allegation. Even if you assume everything that he says is true, he can't support the charges. He got mad. It's obvious. I mean, 8, 9, 10 charges, and he can't work rule violations. He can't even identify coherently what they are. That's the purpose of this hearing, and he failed. He stood up before the entire town of Amory, the entire city, excuse me, and he couldn't put truth to the paper that he didn't even sign. False statements, not even close. And he can't even back up the fact that she does not say in that video, I'm leaving, you'll hear from my attorney. I watched that video just like you did. She doesn't say anything. I couldn't hear the words she said, but there is no way that she said anything like 3 words. You'll hear from my attorney. You can't say that she's even mouthed anything like that. That's a false statement by this gentleman who had how many times, you can't remember how many times, but he had enough time to review this document. And again, this isn't a kindergarten. This is the chief of police who's signing a name to a document. There's no whoopsies here. There's not, I put in 7 charges, but I really only meant to fire her because she was leaving. And you all know that. You know that no judge is going to allow a decision based on testimony like that. He admitted that he has no basis to decide. They tried to go over, rehabilitate him. You can't do it. If you don't remember every conversation, or if you can't sit here and state under oath that you don't remember if you told who else you might have told this to, then you can't say it could only have come from Bethany Escrow. And you can be unhappy about that all day long, but that doesn't change the fact. So every time he said totality, you have to take that, not with a grain of salt, you have to assume it's false. Because if you don't, a judge or somebody else is going to come in here and look and say, what's going on at Amory? Why is it that they're accepting this testimony that's obviously false? And again, anywhere we go from today, this gentleman has got a Brady problem. The city of Amory has a Brady problem because you can't swear to something if you can't tell the truth consistently. And that's all a police officer has, is telling the truth. They ask questions and they testify. That's what they do. And this gentleman is upset. This court clerk is upset that these are so-called disparaging remarks. Well, I encourage you all to read your Garcetti. That's a Supreme Court case that explains this rule quite clearly. I'm confident in it, but hey, I'm just a constitutional attorney. It's what I do. Now, this gentleman here, he isn't. No harm in that. Most people aren't. But he should have done his job. He doesn't even have the training to do his job, to do an investigation.
Who are you referring to?
I submit, excuse me here, to tell the truth. I'm sorry, is there somebody speaking?
Yeah, I just, who are you referring to in this moment, saying he's not qualified to do his job?
That's the police chief, Mr. Hansel, who's taking classes here, who can't conduct an interview without violating the Fifth Amendment, whose entire interview is based on his personal feelings being hurt, and, by the way, violates the First Amendment, and Garcetti. These aren't complicated issues. And I know they arise down here more often in Milwaukee, and you'd think a police officer from Milwaukee who's had to pay out, the city of Milwaukee's had to pay out on these issues time and time again, might have known something about it. For example, if he had actually done an interrogation at the city of Milwaukee, he would have known about about Garrity. but he didn't. So when we talk about plain and simple, what's simple here is Miss Escrow's rights have been violated. What's simple here is we've got him saying this under oath. What's simple here is he can't keep a straight story. What's simple here is go ahead and arrest me in the city of Amory. All you got to do is show the judge, hey, this police department can't tell us to keep a straight story. Judge, you got to let me out. You can't believe their affidavits. This guy's got a Brady problem from now on. And that's what's going to happen is every time this gentleman files an affidavit going forward, he's going to have to put in a note there saying, see this document. And he's going to have to give it over to the other side as exculpatory evidence every time because of Brady. Because he got upset and his feelings were hurt. So I'm going to lay off of the baby now for a little bit. We're going to focus on who did her job. And I submit to you that Miss Escrow did her job. Because working for the police department is more than just showing up. It's being a good citizen. And I'm sorry, your feelings are hurt, but it's free speech. The antidote, the response to free speech in America, and you see that flag over there, this is America, is more free speech. Not censorship, not punishment. This is America. People fought and died for these principles. Not because they're a joke, but because we have freedoms that distinguish us from the rest of the world. And if you want to have a society like North Korea, all it takes is to terminate people for allegedly disparaging the city of Amory. Because we all know whose feelings really got hurt. And that's not a fireable offense, and it never has been. In fact, what we have here is not only a lawsuit, it's possibly the end of this man's ability to ever testify again. So he wasted our time because he cannot prove anything and has not proved anything else, then he can't successfully tell the truth. There's a reason he didn't sign his name to these charges, and it's plain. He admits that he doesn't know. He admits that there's other possibilities. He admits that there's nothing false. It all boils down to his feelings are hurt, and we all know it. I thank you for your time.
Okay. So that was a lot, right? We got kind of a saying in the practice of law, and you probably all heard this before, when the facts are on your side, you argue the facts. When the law is on your side, you argue the law. And when neither is on your side, you pound the desk. We just spent the last 2 hours listening to a lot of pounding on the desk. There's a reason why the plaintiff's arguments are confusing. That's intentional. When you have a clear case and it's simple and it's straightforward that someone said, I'm leaving in the middle of the day, you'll hear from my lawyer, not just walking out the door and going to the bathroom. Packed up the purse. You see it in the video. But you see, if you look closer in that video, if you can get a little closer to it, and we can make the video available, it's an open record. You just have it. She grabs her lunch. She packs up 2 things. It's a Tupperware thing. She puts it in her purse, shuts off her light. She's leaving. She's not going to the bathroom. Everybody in this room goes to the bathroom. How many times a day? You grab all your stuff and you go to the office bathroom. Maybe you grab your purse. I don't know. My wallet's always in my pockets, which is with me, but you don't shut off your light. You don't grab your lunch to go to the bathroom. The heck are you going to do with your lunch in the bathroom? So listen, we don't need to overcomplicate this. We know what happened that day. That's why the termination occurred. What we've heard now for the last, during this closing arguments, you know what we heard? We heard conjecture. We heard bullying. We heard attacking, name calling, all towards our police chief. You know, we didn't hear much of anything about Miss Escrow. Why? I'll tell you why. Because they don't have a case. Their case is to make our case look confusing and unsure. And, well, did you know that? Did you remember what you said 6 weeks ago to that guy on the traffic corner? No, who here could possibly recall every conversation they've had with everyone they've ever talked to? You will recall using specific language with someone if it showed up in a post about you a few weeks later. That's not unreasonable to believe. That's clear. But you don't want to have that be evidence that you're stuck with. So you're going to confuse the hell out of it by asking 15 different questions, going all over the place about the code, mischaracterizing evidence, misstating evidence, stating evidence that's not actually in the record from tonight's hearing. That's what we just heard in that closing argument. I'm not here to confuse you. I'm not here to ramble us up in Fifth Amendment, which, by the way, Fifth Amendment applies to criminal proceedings. Through his own questioning, Attorney Hitchcock made it clear that this wasn't a criminal proceeding. This is an employment proceeding. It was an employment investigation. Fifth Amendment applies to criminal searches and seizures. Your criminal right to not incriminate yourself, your rights to not incriminate yourself in a criminal proceeding, not an employment hearing. We all know it through the testimony. The interrogation room was only used out of convenience and for sake of privacy. They don't have an office space where there's a conference room. They got an interrogation room. It's a police department. Another thing that was misstated. Disposable income is the term that the police chief used for the amount of money he lost as a result of his wife's income. He didn't say a substantial amount. He didn't say he was upset about that. All he did say was he didn't care. Disposable income. He didn't say anything substantial. He's not angry about this. He's not out to get any revenge on this, yet that's how he's being characterized. But that's not in the evidence. That's not what the testimony said. Signing a document. This is an oversight. He doesn't deny drafting the letter. He said right here today on testimony he would sign it. He's not running from standing behind his testimony. Everyone's signing something, but he acknowledges he wrote the letter. As an attorney, I tell you, we submit things to the court to say electronically signed by me every day of the week. I don't remember the last time I signed something that I submitted to the court. Electronically signed, not signed, he drafted it. He's not hiding behind it. By the way, it wasn't an affidavit. It's not a sworn statement. It's an employment letter. He had to inform her why she was terminated. That's all that was. Let's not make more out of it than he's trying to make out of this. It's simple. He had an obligation to tell her why she was terminated. That's what that letter achieves. He doesn't have to prove each and every element of every of the allegations that were made against her. She could be terminated for any one of those reasons. And we know now after testimony why. It was insubordination. It was unexcused absence. She left in the middle of the day. Ask yourselves, you all have jobs. You got up in the middle of the day and told your boss, I'm leaving. You'll hear from my lawyer. Come on, we're reasonable people. What would you think that meant? You think I'm going to lunch? Jesus, if I said you'll hear from my lawyer every time I got up to leave the office, you all would think I was crazy or quitting or should be fired. I mean, let's come on, we're laughing, but let's be reasonable. That's what happened. We know what happened there that day. Okay? Totality of the circumstances. In legal speak, this means something to us, right? If I walk in and I see a dead body on the ground and someone holding a gun, smoking a gun, with a smoking gun, I don't need a totality of the circumstances argument. I've got evidence. I've got clear, convincing evidence. Totality of the circumstances is when a person shows up at an event, something happens at an event, you find out a year ago, that person was involved in a similar event. They just happened to be at this time where this event occurred. That's not enough grounds to convict somebody. That's enough grounds to start an investigation on somebody. So let's think about this. You had a prior reprimand for a Facebook post. Now, we're not saying that prior Facebook post that Ms. Escrow was involved with before was a disparaging comment. From what I understand from when we looked at it, is she was answering city questions on a Facebook post on behalf of the city, which was not her authority or her role to do. And that's what it was. But she was trying to be helpful. It wasn't a negative thing. But on that Facebook post, the page itself, apologize, it's gossip or something around Amory is the name of the post. Well, you guys know what post I'm talking about. So you have that. Then you have the picture. We know she took the picture. Then that picture shows up on that same post by City Watch. And then we have the post about the professional classes, and we know that was only used with one person, at least within this building. Who knows if that's a word he used with his wife or not? Who knows? And who cares? We know that that's not what he said at the staff meeting, but it is what he said to her individually. When you put those three things together, there was grounds for an investigation. This was not a witch hunt. This was not a retaliation. Someone in his department, he believes, is out there disparaging the city of Amory and the police department. You all know this has been a rocky ride since the police chief got here in January. He's trying to calm the ship down, and the ship is not going to get calmed down if someone internally is constantly trying to undermine him. Now, he doesn't know if that's happening or not. He was doing an investigation. Now, I'll tell you this. What does it look like to you if I'm asking you questions about this activity on Facebook posts and you're being evasive and you don't want to answer the question and you keep repeating that it's it's a public comment, and you won't talk about who you shared these things with, and then a minute later you're packing up your bags and you're leaving? If the police chief had not come around the corner just to remind her that also includes text messages and emails, he wouldn't have known she was leaving. He just happened to come around. She came out of that interview room intent on walking out the door. Why? If she had nothing involved with City Watch, wouldn't you be more laughing about this? Wouldn't you be like, this is crazy? I don't know. Only she can say that, but she didn't testify here tonight. No questions were asked of her here tonight. Her attorney didn't present really any evidence on her behalf. All he did was attack your police chief.
That's outrageous. That's outrageous. We'd be happy to have her testify, but you wouldn't let us have anybody else testify. So let's get her up there and testify then. She's happy to testify. What are you talking about?
You're happy to cross-examine her if he wants to bring her up. I have tons of questions from
I bet you do. But that's not what we said. You want Mr. Hickok to come on. We asked to have him on. You wouldn't let us do that. So you're going to play that we can only cross-examine. That's just fine. But don't sit here and pretend like you can have it both ways, sir, because that's outrageous.
I retract my
No. You objected to having Mr. Hickok testify.
I did.
And then you are saying that she should have testified. Well, you can't play both ways and say we can only cross-examine if you're going to say that she should have testified. That's preposterous and it's abusive.
I said you didn't have her testify.
Right. You won't let us. You wouldn't let us have Mr. Hickok, did you?
Speak.
Uh-huh.
I asked if she wanted to speak before we went into closing.
Sure. Speak. That's testify. He didn't say speak. He said testify.
I'm sorry that I didn't use the legal jargon that you would have preferred. I'm not a lawyer.
Constitutional lawyer at that. Things are different down in Milwaukee. Up here, we have decorum. Up here, we treat each other with respect. We don't yell and bully each other. And we don't throw around how big time we are and what kind of lawyers we are. We just do our jobs. So I'm just going to wrap this up. You guys know what this is about. This was about a termination, an appeal of a termination. There is 3 hours of nonsense that got spewed around this room tonight. Plain and simple. Person packed up to leave in the middle of the day. That is not acceptable at any employment. Oh, and let me part with this. Wisconsin's an at-will employer. Okay, he cited some case law. Let's cite some case law ourselves. Brockmeyer v. Dunn Bradstreet. An employer may discharge an employee for good cause, for no cause, or even cause morally wrong without they're thereby guilty of legal wrong. Now, that's some old legal jargon, but what it means is an at-will employer, I don't really need a cause in the state of Wisconsin. I can't do it discriminatorily. I can't do it against public policy. But neither of those things happened here. She was terminated because she got up and walked out in the middle of the day. It's as easy as that. With that, we finish our comments. We appreciate everyone's time here this evening and allowing us to be heard. Thank you.
Thank you. How would the council like to proceed?
What are the rules? I guess I don't know.
Well, we had closed session and Ms. Esco waived her right to a closed session, so we had an open session. We've heard testimony and opening and closing and testimony from both sides. And now it's up to us to decide, do we want to take action now, or do we want to well, I don't know that we can take action because it's not on the agenda to take action.
I think we need to discuss this further amongst ourselves.
I also think it's fair of us to ask for some time to digest everything that we've been given. This is 3 hours of information. I don't think that it's fair for us to make a choice about someone's livelihood without having time to think about all of the evidence that's been provided by both sides.
And I agree with that.
And then I guess I would entertain a motion for adjournment, unless you have something.
What I would say is I think it would be best to put a date or a date out in the future that we have make this determination. Otherwise, it's just out there. I think we need to do this as soon as we can. I agree with a little bit of time, but I also think we need to put something out there so we move on it.
Right.
Well, we have a council meeting next Wednesday.
Next Wednesday,
That needs to be on our agenda.
the 7th.
With that, I'm fine.
With that, I have a clarifying question. So generally, when it comes to employment, these things are done in closed session. Because this was done in open session, is the expectation that that conversation happens in open session, or is it still something that happens in closed?
Ultimately, that would be at.
We'd like to have an open vote.
Okay, I agree with that. That's only fair.
Great.
Okay, so that'll be on the agenda then for June 7th. Okay. All right.
Okay. Yeah, I don't think we're not trying to kick this down the road. I think we want to be respectful of the information we've received and the way it was presented.
I appreciate the time limits, and just speaking on behalf of Ms. Esco, I think that this, the way you're planning to proceed is just fine.
I agree with this too, because I don't make any rash judgments right now. There's been a lot of information that's been brought forward to us today, this evening, and I would feel comfortable what everybody else agreed on, giving us some time to digest this.
And just, I know that this should go without saying, but I just want to reiterate that the council members are not allowed to talk to each other at all about this. So I just want to put that out there and make sure that we're not doing anything that we should not be doing.
Okay. Move to adjourn.
And I'll second that.
Okay, any further discussion? All those in favor?
Aye.
Opposed? All right, we're adjourned. Thank you very much.
Thank you for coming. Thank you for participating. That's because there's no runs on TV.